Hello, fellow Georgia lawyers. Let's talk about one of the fastest ways to turn a disgruntled client into a bar grievance or a claim: refusing to turn over the client's file. Whether a client's changing counsel or closing out a matter or suddenly deciding they want to send their file to their tax preparer, Georgia ethics rules are crystal clear. You cannot hold a client's file hostage, not for unpaid fees, not because you're mad, and definitely not because you want more time to scrub those sticky notes where you called their case a complete train wreck. Georgia Rule of Professional Conduct 1.16D and Formal Advisory Opinion 87-5 provide that client's interest comes first, period. Most everything in the file is the client's property. And yes, you can make a copy for yourself, especially if you're worried about a grievance or a malpractice claim. But you can't refuse to hand it over. And here's the part too many lawyers miss: check your malpractice policy. A simple request for the file could be considered enough to put you on notice of a potential claim under your policy's language. You miss that notice requirement, and your carrier might try to deny coverage when you need them the most. Plus, you want to keep a copy of the file to defend yourself if a malpractice claim or grievance later rises. Here's a pro tip: keep your files clean. Don't write anything you wouldn't want to read back under oath in court. And run your practice like every client will request their file, because one day they will. At Chandler Law, we handle these issues every day, both in defending lawyers and helping law firms tighten up their procedures before a problem happens. If you've got a question about a client's file request, a subpoena, a potential claim, or a potential grievance, or want a game plan to protect your practice, please call us.